Welcome back to another episode of Case of Interest Kohberger. I'm Newswatch 16's Stacey Lang. Last we met, we thought we were going forward for a trial set to start on August 11th. There has been a bit of a complication that may change that, though we're going to get an expert's thought on whether or not this will change it. Late last night, Kohberger's defense team filed a motion to continue. It is lengthy. It has lots of points that they're making an argument for delaying the trial. One of the biggest points they make, though, has to do with one of the biggest happenings in the Kohberger trial right now, and that is the supposed leak of information to Dateline NBC for their 2-hour special on this case that aired a few weeks ago. We'll talk about all of that, but that's just one of the many points that was made in this motion to continue. I'm joined over the phone with Brett Riegel, who is a defense attorney from Stroudsburg from Arm Lawyers. Brett, we've talked to you lots about this case, and we wanted to get your take here. What do you think about some of the points that Kohberger's defense team makes in this motion to continue?
So first, thanks for having me. Second, I had the opportunity to read the 40-ish page motion earlier, and I would kind of divide the issues into two categories. Category number one is we're not ready because every time we're going down a rabbit hole, we discover that we need to go further down it. And I'll talk about that in a second. And then the other is, and hey, it appears that somebody on the prosecution team is not playing fair, is violating the earlier gag order, and this is going in a direction where there's the potential for pretrial publicity that would basically poison any jury pool. So we should let some time pass to see whether or not the interest dies down, memories for jurors fade, etc. So that's kind of the two broad categories that we have there. Which one do you want to tackle first, Stacey?
Let's talk about the first one first, because that's really the bulk of the filing, right? Is the rabbit hole nature of this case. There's so much information, and also a lot of the filing has to do with preparation, the rabbit hole when it comes to the penalty phase.
Correct. Yeah. Anytime you're talking about a death penalty case, it's important to remember that you're going to have two pieces to it. The first piece is the guilt phase, or the did he do it? Is there an excuse, a justification? Is there a defense of some sort that a jury accepts or that a judge finds is appropriate, so that we don't even get to the sentencing phase? And then the sentencing phase separately is this a person who should face the death penalty, and does the jury believe the death penalty is an appropriate consequence for what it found happened in the guilt phase? So you have a lot of different ways that it could go as the relationship between those two phases develops. Just to make a probably ridiculous, but an example that might help bear that out a little bit. If there were a finding that Kohberger committed one homicide, not all of them, and the others were found by the jury to be something else or somebody else, now the question becomes, is he even eligible for the death penalty under Idaho's rules on when the death penalty is appropriate? So there's a link between what the fact finder determines happened in the guilt phase and then moving to the penalty phase. But the penalty phase is where the defense spends a lot of time dealing with a concept known as mitigation. Mitigation is basically, what is there about this person that even if they committed these acts, because the jury by that point has found that they did, what is there about this person that means the death penalty is not appropriate? And the defense appropriately notes in their motion, they said, look, death is different, because in normal circumstances, a judge looks at what the person is convicted of. They look at some sentencing guidelines. They look at law regarding sentencing, and then they fashion what is supposed to be a fair consequence. But here, they're putting in the hands of a jury really a binary decision of life or death. It's life in jail or it's the death penalty. And because a jury could find pretty much anything as mitigation, the defense really has to dig and dig and dig and dig to decide what's out there and what they want to put in front of the jury. And the problem with these cases is as you dig in one direction, it's not at all unusual to come across something that causes you to now need to go in one or two or three additional directions so that you have all the information that you need. Like, again, an example, let's say that you learned that Kohberger was a Boy Scout and that he left the troop when he was a second class or something like that. And you ask him why. He says, well, there was a thing with the leadership. Well, now you've got to dig into what that was. Are we talking about whether or not there may have been abuse or mistreatment, or are we talking about a personality conflict? Are we talking about he didn't like going camping? You know, what is it? And sometimes the client isn't the greatest source of the information that you need. You have to run those things down, and that just takes a lot of time and effort.
Because you're right, they're looking into every single aspect of his life.
Yes. And even things that we would look at now and say, well, hang on, how does that really apply? But you've got to dig further in to determine whether or not there was an omission. So, for example, looking at somebody in the light of what we know in 2025 about things like autism or spectrum disorders is different than how he may have been looked at in the late 80s or early 90s. So was the diagnosis missed? Would that have made a difference? Should there have been different treatments, circumstances, programs, etc.? And does the fact that he didn't benefit from the best that we as society have to offer mean that that's a reason that we shouldn't put him to death?
And they're going to find any scrap of evidence over the course of his entire life to try and defer that.
Sure, and then they have to decide which of the scraps are things that they want to put together and put in front of a jury. Because there are going to be some things that, obviously, if you had nothing to work with, then the tiniest scrap is what you would put in front of the jury, right? But if you've got a lot of different things, now you have to go through and make a decision, because there has to be a coherent strategy and a coherent presentation to the jury so that they can understand this person's life. You can't just kind of pull something, oh, well, here's something that happened when he was 11 and throw it at them and hope that they understand it. You've got to decide how this fits into the overall description and the overall evidentiary plan so that they're receiving coherent, usable, meaningful information rather than a bunch of tic-tacs hoping that they figure out how to put it together.
Do you know of any instances where in a capital case, the criminal trial happens and then there's a gap of time and then the penalty phase, or do they always roll right into the other one?
Great question. I can tell you that sometimes there will be a gap in a trial by judge, or if the sentencing has been reserved to a judge. But I'm not aware of it happening with a jury, primarily because you're already taking people out of their everyday lives for a substantial period of time. And so taking a break would put them back into the world, so to speak, and then bring them back. And that just is a recipe that's fraught with problems. Does a juror go home and talk with their spouse? And now they come back with a different attitude or a different thought process than they had before? Do they get exposed to something that is either reported in the media or a source of gossip or what have you that now changes their mind and their approach? And that would be just a fraught with peril for both sides.
Mm-hmm. And that kind of leads us to the next big point in this motion to continue, and that is the information that is out there, specifically information that is believed to have been leaked outside of that gag order. And I mentioned the Dateline NBC special at the beginning of this. I did not mention, though, that the filing also mentions a James Patterson book that is scheduled to be released, I think, 2 weeks before the trial is set to begin.
Yep.
And this,
it was 16 days.
Yeah.
Very specific about it.
Very specific. Do you think that this is the point that might get Kohberger's team over the edge?
I wouldn't be surprised with either point carrying them over the edge, and both together certainly seems substantially stronger. Because, I mean, these are ridiculously expensive things to undertake, right? So you don't want to do it twice. And if the question is, does more time solve the problem? It's as long as you have a waiver of the speedy trial rights from the defendant, you're generally going to see the court say, okay, if we've got a good reason, it makes more sense to continue it and do it right once than to try to get it right and then discover that instead of getting it right, we've got a mess.
Judge Stephen Hippler, who is overseeing this case, the Ada County judge in Boise, Idaho, has seemed hell-bent on making sure that this goes this year. And we just had a hearing 2 weeks ago where they were, getting into the minutia of when lunch breaks are going to be and when they're going to take a break for Labor Day weekend. So it seemed like this was going to go forward, and he really wants that to happen. Then this order came down 1 day later about the leaked information. So who knows if that might throw a wrench into his plans. But as a defense attorney, I want your take on that order. What's it called? Document and Records Hold Order. What is, both the defense and the prosecution received this order. If you're one of those attorneys and you read that language from the judge, what are you thinking?
You're thinking immediately to yourself, oh my gosh, did I do anything I wasn't supposed to do? And somebody out there is probably thinking to themselves, oh boy, I am in deep trouble. If in fact there was a leak. Now, I mean, who knows how the information was obtained? Who knows whether it was pieced together? But it looks from reading the motion like there are some very specific things referenced in the Dateline show that are problematic because they couldn't have come from somewhere else other than one of the sides. So part of the question becomes digging into, who did it? Was it somebody on the prosecution team, or was it what you'd refer to as a false flag operation where somebody on the defense team actually did it? Because bottom line really is somebody's likely to get in serious trouble because there is a gag order, a very specific one, and it appears that the terms of it have been at least ignored in some respects, if not just outright violated on purpose.
What are the possible outcomes of this investigation, if that's what we want to call it?
Well, I don't know what Idaho provides for in terms of a consequence for what's called indirect criminal contempt. So there's basically two ways that you get in trouble for violating a court order. Way number one is direct contempt, which is like you're standing in front of the judge and the judge says, Mr. Regal, no more questions. And I go ahead and ask a question. The judge can hold me in contempt for that because I've disobeyed him directly. The indirect criminal contempt is when somebody who's under a court order not to do something or to do something doesn't do what they're supposed to do outside the presence of the court. In Pennsylvania, that's generally punishable by up to 6 months in jail, up to, I believe it's a $1,000 fine. And the judge could really read this to provide that every different piece of information is a separate contempt. So you could build quite a substantial violation there if you were pursuing it that way. Oftentimes, there are also potential for criminal charges, depending upon who it was, what duties they have, what information exactly was provided. And one of the things that happens in today's society, and the reason for the judge's order, is that people don't leak things by meeting, at the corner diner and having a cup of coffee, they leak things by sending texts and emails and postings and Instagrams and things like that. And so the court's trying to make sure that its evidentiary trail is there to figure out who did something wrong, or whether you simply have excellent investigative journalism that involved getting little tiny pieces that are not violative of the order and then figuring out what the grand scheme looked like.
Mm-hmm. And either way, that sounds like that's going to take time to figure out. So we're going to have to see how that plays into. Yeah.
The big question there is, does the judge try to run the investigation into this alongside the trial prep, or does he stop the trial prep until they figure out what's going on? Like, again, think back to, one of the most televised and of national interest trials that we've had, the O.J. Simpson case, right? 30 years ago. But some of the lessons learned there, how many times did Judge Ito have a trial within a trial in the middle of the case to address some issue or another that one of the sides brought up? Similarly, the judge here could decide, hey, I'm going to grant a continuance on the issue of trial. We're not even going to try to impanel a jury. We're going to get to the bottom of this issue of whether or not my order was violated. And yes, defense, you need to keep digging on your mitigation evidence. I'm not going to tell you to stop the investigation, but I'm going to tell you that we're not going to trial in August. Or alternatively, the judge could say, look, right now it's May 22nd or 23rd, whatever day we're on, and we've got 2.5 months to figure this out. We're going to do that. And we're still going forward full steam ahead, trying to select a jury in August.
Well, we'll have to stay tuned, and we'll be calling on you again. There's going to be lots more to talk about in the next 2.5 months. Brett, we really appreciate your time and your insight. Thanks for joining us for Case of Interest.
My pleasure.
Thanks so much.
Great to talk to you.
Great to talk to you.